All right, let's talk about something we all deal with, credit agreements. And maybe you've been asked to be a cosigner, which is a whole other level of complicated. You're faced with all this complex language, that super tiny fine print. It can be pretty intimidating. But here's the thing, knowing your rights is your absolute best defense. So let's jump right in and figure out how to decode these things together. I mean, have you ever had that feeling you're just staring at a contract and it's like a wall of text and you're thinking, what am I even signing? What traps are hiding in all this legal jargon? Well, what if I told you that South African law actually gives you some hidden shields, some secret deal breakers? That's what we're going to do right now. We're going to uncover them, and by the end of this, you'll have the tools you need to look at any credit agreement with way more confidence. Okay, first up, let's talk about the absolute deal breakers. We're talking about situations where a credit agreement is just unlawful, right from the very start. And when I say unlawful, I mean it's void. That's a really important word. It means it's as if the contract never even existed. It's totally unenforceable. The trick, of course, is knowing what these red flags actually look like. So what exactly are these deal breakers? Well, there are four major ones you got to watch out for. Number one, is the credit provider even registered? If they're supposed to be registered with the National Credit Regulator and they're not, boom, the agreement is void. Simple as that. Number two, who signed the thing? If it was signed by, say, a minor without their guardian's help, or someone who's been declared mentally unfit by a court, that's a total non-starter. The agreement's no good. Third, and this is a big one, keep an eye out for illegal clauses. A classic example is a clause that tries to get you to sign over your power of attorney. No way, that's a huge red flag. And finally, number four, watch out for something called negative option marketing. You know what this is. It's that really sneaky tactic where a company says, we're going to give you this service, and if you don't tell us to stop, we'll start charging you. If a credit agreement is created that way, it's unlawful from the start. Okay, so what if the agreement doesn't have any of those big red flags, What if it looks totally legit? Well, even then, you still have a set of fundamental rights, and I want you to think of these as your own personal, unbreakable shield. These are defenses that are so important that the law says you can never sign them away. It doesn't matter what the fine print says, they're yours, period. And look, this isn't just some nice idea or a helpful tip. This is baked right into the law. We're talking about Regulation 32 of the National Credit Act. This is a seriously powerful piece of regulation because it takes these old, established common law rights and says, nope, these are non-negotiable. It's basically your permanent legal safety net. All right, so the first piece of your shield has one of those fancy Latin names, but don't worry about that. The meaning is super simple. It's called exceptio non numerate pecunia, which is really just the prove I got the money defense. And man, is it powerful. It means that if a creditor comes to you and says you owe them money, the responsibility is on them to prove that you actually received the loan. If they can't prove the funds were transferred to you, there's no debt. It's that simple. Next up in your toolkit is another Latin one, exceptio arrere calculi, or, as I like to call it, the check the math defense. And this one is just so practical, so useful. It's your absolute right to challenge the numbers. So if you're looking at a statement and you think, hang on, that interest calculation doesn't look right, or where did this fee come from? This defense gives you the power to formally dispute it and make them show their work. And the third one, this might just be the most powerful defense of them all. Exceptio non causa debiti. Think of this as the ultimate, why do I owe this defense? See, with this one, you're not just questioning the calculations, you are challenging the very foundation of the debt itself. You're basically saying, show me the valid legal reason why this debt even exists. It's your ultimate weapon against a claim that just doesn't have a legitimate basis. Okay, so we've been talking about your rights when you're the main borrower. But what happens when a friend or family member asks you to co-sign a loan for them? Well, that makes you a surety. And as a surety, you do have certain rights. But, and this is a huge but, so please pay close attention. Unlike that unbreakable shield we just discussed, these rights can be signed away. And honestly, in almost every single suretyship agreement, they are. Let's break this down. First, you have something called the benefit of excusation. In theory, this means the creditor has to go after the person who actually took out the loan first and only come after you, the cosigner, if they can't get the money. Sounds fair, right? But look at the fine print. That right is almost always waived, which means they can come after you right away. Then there's the benefit of division. This should mean that if there are a few cosigners, the debt gets split between all of you. But again, that right is almost always waived in the contract. And that makes you personally responsible for the entire debt, not just your share. So the main takeaway here is absolutely crucial. When you co-sign, you are very likely agreeing to be on the hook for the full amount from day one. You have to read that fine print. Wow. Okay, we have covered a lot of ground here, right? From spotting totally unlawful deals to understanding what happens when you co-sign. So let's wrap this up. Let's distill everything down into a simple, powerful toolkit that you can actually use to protect yourself. Here it is, your 3-point protection plan. First, always check for those deal breakers we talked about. Is the credit provider registered? Are there any weird prohibited clauses? Is the whole thing just void from the start? Second, never forget about your unbreakable shield. Remember, you can always question whether the money was actually transferred, you can always challenge the math, and you can always question the basic reason for the debt. And third, if you're thinking about co-signing for someone, you have to scrutinize that fine print. You need to know exactly what rights you're giving up before your pen ever touches that paper. Look, at the end of the day, it really comes down to this. Knowledge isn't just power, it is your absolute best protection. I guarantee the next time a credit agreement lands in front of you, you're going to see it in a whole new light. You'll know what red flags to look for, what questions you need to ask, and most importantly, you'll know which of your rights you can never, ever surrender. So I'll leave you with a question to think about. After all this, what's the one thing you're definitely going to look for in your next contract?